Hi everyone, this is Narendra Sirswa and welcome to Udan. Supreme Court is very interesting topic. Unlike the American Constitution, the Indian Constitution has established an integrated judicial system with the Supreme Court at the top and the high courts below it, under a high court and below the state level. This is a hierarchy of subordinate courts, that is district courts and other lower courts. This single system of courts adopted from the Government of India Act of 1935. This is very important. Remember this. Enforces both central laws as well as the state laws. In USA, on the other hand, the federal laws are enforced by the federal judiciary and the state laws are enforced by the state judiciary. This is thus a double system of courts in USA, one for the center and other for the states. To sum up, India, although a federal country like the USA, has a unified judiciary and one system of fundamental law and justice. The Supreme Court of India was inaugurated on January 28, 1950. It succeeded the Federal Court of India established under the Government of India Act of 1935. However, the jurisdiction of the Supreme Court is greater than that of its predecessor. This is because the Supreme Court has replaced the British Privy Council as the highest court of appeal. Under Articles 124 to 147 in Part 5 of the Constitution, deal with the organization, independence, jurisdiction powers, procedures and so on of the Supreme Court. The Parliament is also authorized to regulate them. Next is composition and appointment. At present, the Supreme Court consists of 34 judges, 1 CJI and 33 other judges. In 2019, the Centre notified an increase in number of Supreme Court judges from 31 to 34, including the CJI. This followed the enactment of the Supreme Court Amendment Act 2019. Originally, the strength of the Supreme Court was fixed at 8, 1 CJI and 7 other judges. The Parliament has increased this number of other judges progressively to 10 in 1956, to 13 in 1960, to 17 in 1977, to 25 in 1986, to 30 in 2008, and to 33 in 2019, excluding CJI. Next is appointment of judges. The judges of Supreme Court are appointed by the President. The CJI is appointed by the President after consultation with such judges of the Supreme Court and High Courts as he deems necessary. The other judges are appointed by President after consultation with the CJI and such other judges of the Supreme Court and the High Courts as he deems necessary. The consultation with the CJI is obligatory in the case of appointment of judge other than CJI. Next is controversy over consultation. The Supreme Court has given different interpretation of the word consultation in the above provision. In the first judge's case, 1982, the court held that consultation does not mean concurrence and it only implies exchange of views. But in the second judge's case, 1993, the court reversed its earlier ruling and changed the meaning of the word consultation to concurrence. Hence, it ruled that the advice tendered by the Chief Justice of India is binding on the President in the matters of appointment of the judges of the Supreme Court. But the CJI would tender his advice on the matter after consulting two of his senior-most colleagues. Similarly, in the third judge's case, 1998, the court opined that the consultation process to be adopted by the CJI requires consultation of plurality judges. The sole opinion of the CJI does not constitute the consultation process. he should consult a collegium of 4 senior-most judges of the Supreme Court, and even if 2 judges give an adverse opinion, he should not send the recommendation to the government. The court held that the recommendation made by the CJI without complying with the norms and requirements of the consultation process are not binding on the government. The 99th Constitutional Amendment Act of 2014 and the National Judicial Appointments Commission Act of 2014 have replaced the collegium system of appointing judges to the Supreme Court and High Courts with a new body called the National Judicial Appointments Commission, NJAC. However, in 2015, the Supreme Court has declared both the 99th Constitutional Amendment as well as the NJAC Act as unconstitutional and void. Consequently, the earlier collegium system became operative again. This verdict was delivered by the Supreme Court in the 4th Judge's case 2015. The court opined that the new system, in example NJAC, would affect the independence of the judiciary. Next is appointment of chief. Justice from 1950 to 1973, the practice has been to appoint the senior-most judge of the Supreme Court as the CJI. This established convention was violated in 1973 when A.N. Rai was appointed as the CJI by superseding 3 senior judges. Again in 1977, M.U. Beg was appointed as the CJI by superseding the then senior-most judge. This discretion of the government was curtailed by the Supreme Court in the 2nd Judge's case 1993, in which the Supreme Court ruled that the senior-most judge of the Supreme Court should alone be appointed to the office of the CJI. Next is, what are the qualifications, oath and salaries? So first, qualification of judges. A person to be appointed as a judge of the Supreme Court should have the following qualification. First, he should be citizen of India. Second, he should have been a judge of a high court or high courts in succession for 5 years. Or he should have been an advocate of a high court or high courts in succession for 10 years. Or he should be a distinguished jurist in the opinion of the President. From the above, it is clear that the Constitution has not prescribed a minimum age for appointment as a judge for the Supreme Court. Next is oath or affirmation. A person appointed as a judge of the Supreme Court before entering upon his office has to make and subscribe an oath or affirmation before the President or some person appointed by him for this purpose. In his oath, a judge of the Supreme Court swears what? Number 1, to bear true faith and allegiance to the Constitution of India. Second, to uphold the sovereignty and integrity of India. Third is to duly and faithfully and to do the best of his ability, knowledge and judgment, perform the duties of the office without fear or favor, affection or ill will, and to uphold the Constitution and the laws. Next is salaries and allowances. The salaries, allowances, privileges, leave and pension of the judges of the Supreme Court are determined from time to time by the Parliament. They cannot be varied to their disadvantage after their appointment except during a financial emergency in 2018. The salary of the Chief Justice was increased from rupees 1 lakh to 2.80 lakh per month, and that a judge from 90,000 to 2.50 lakh per month. They are also paid sumptuary allowances and provided with free accommodation and other facilities like medical, car, telephone, etc. The retired CJI and other judges are entitled to 50% of their last drawn salary as monthly pension. Next is tenure and removal. Tenure of judges. The Constitution has not fixed the tenure of a judge of the Supreme Court. However, it makes the following three provisions in this regard. First is, he holds office until he attains the age of 65 years. Any question regarding his age is to be determined by such authority and in such manner as provided by Parliament. Second is, he can resign his office by writing to the President. Third is, he can be removed from his office by the President on the recommendation of the Parliament. Next is removal of judges. A judge of the Supreme Court can be removed from his office by an order of the President. The President can issue the removal order only after an address by Parliament has been presented to him in the same session for such removal. The address must be supported by a special majority. Remember this, special majority of each House of Parliament. In example, a majority of the total membership of that House and a majority of not less than 2/3 of the members of that House present and voting. The grounds of removal are to prove misbehavior or incapacity. The Judges Inquiry Act 1968 regulates the procedure relating to the removal of a judge of the Supreme Court by the process of impeachment. First is, a removal motion signed by 100 members in the case of Lok Sabha or 50 members in the case of Rajya Sabha is to given to the Speaker or Chairman. The Speaker or Chairman may admit the motion or refuse to admit it. Third is, it is admitted, then the Speaker and Chairman is to constitute a 3-member committee to investigate into the charges. Fourth is, the committee should consist of A, the CJI or a judge of the Supreme Court, B, a CJI or a High Court and a distinguished jurist. Fifth is, if the committee finds the judge to be guilty of misbehavior or suffering from an incapacity, the House can take up the consideration of the motion. After the motion is passed by each House of Parliament by special majority, an address is presented to the President for removal of the judge. Finally, the President passes an order removing the judge. It is interesting to know that no judge of the Supreme Court has been impeached so far. The first case of impeachment is that of Justice V. Ramaswamy of the Supreme Court, 1991 to 1993. Though the inquiry committee found him guilty of misbehavior, he could not be removed as the impeachment motion was defeated in the Lok Sabha. The Congress party abstained from voting. Next is acting ad hoc and retired judges. Acting Chief Justice. The President can appoint a judge of the Supreme Court as an acting Chief Justice of India when the office of Chief Justice of India is vacant, or the Chief Justice of India is temporarily absent, or the Chief Justice of India is unable to perform the duties of his office. Next is ad hoc judge. When there is a lack of quorum of the permanent judges to hold or continue any session of the Supreme Court, the Chief Justice of India can appoint a judge of High Court as an ad hoc judge of the Supreme Court for a temporary period. He can do so only after consultation with the CJI of the High Court concerned and with the previous consent of the president. Sorry, Chief Justice of the High Court consent and with the previous consent of the president. The judge so appointed should be qualified for appointment as a judge of the Supreme Court. It is the duty of the judge so appointed to attend the sittings of the Supreme Court in priority to other duties of his office. While so attending, he enjoys all the jurisdiction powers and privileges and discharges the duties of a judge of the Supreme Court. Next is retired judge. At any time, the Chief Justice of India can request a retired judge of the Supreme Court or a retired judge of a High Court who is a duly qualified for appointment as a judge of the Supreme Court to act as a judge of the Supreme Court for a temporary period. He can do so only with the previous consent of the President and also of the person to be so appointed. Such a judge is entitled to such allowances as the President may determine. He will also enjoy all the jurisdiction powers and privileges of a judge of Supreme Court, but he will not otherwise be deemed to be a judge of the Supreme Court. Next is seat and procedure. Seat of Supreme Court. The Constitution declares Delhi as the seat of the Supreme Court, but it also authorizes the CJI to appoint other place or places as seat of the Supreme Court. He can take decision in this regard only with the approval of the President. Remember this. This provision is only optional and not compulsory. This means that no court can give any direction either to the President or to the CJI to appoint any other place as a seat of the Supreme Court. Next is procedure of the court. The Supreme Court can, with the approval of the President, make rules for regulating generally the practice and procedure of the court. The constitutional cases or references made by the President under Article 143 are decided by a bench consisting of at least 5 judges. All other cases are decided by single judges and division benches. The judgments are delivered by the open court. All judgments are by majority vote, but if differing, then the judges can give dissenting judgments or opinions. Next is independence of Supreme Court. The Supreme Court has been assigned a very significant role in the Indian democratic political system. It is a federal court, the highest court of appeal, the guarantor of the fundamental rights of the citizens and guardian of the Constitution. If a question asks to you, who is the guarantor of the fundamental rights of the citizens and guardian of the Constitution, then your answer is Supreme Court. Therefore, its independence becomes very essential for the effective discharge of the duties assigned to it. It should be free from the encroachments, pressures, and interferences of the Executive, Council of Ministers, and the Legislature, Parliament. It should be allowed to do justice without fear or favor. The Constitution has made the following provisions to safeguard and ensure the independent and impartial functioning of the Supreme Court. First is mode of appointment. The judges of Supreme Court are appointed by the President in consultation with the members of the Judiciary itself. This provision curtails the absolute discretion of the executive as well as ensures that the judicial appointments are not based on any political or practical consideration. Next is security or tenure. The judges of the Supreme Court are provided with the security of tenure. They can be removed from office by the President only in the manner and on the grounds mentioned in the Constitution. This means that they do not hold their office during the pleasure of the President, though they are appointed by him. This is obvious from the fact that no judge of the Supreme Court has been removed or impeached so far. Third is fixed service conditions. The salaries, allowances, privileges, leave and pension of the judges of the Supreme Court are determined from time to time by the Parliament. They cannot be changed to their disadvantage after their appointment except during a financial emergency. Thus, the condition of service of the judges of the Supreme Court remain same during their term of office. Fourth is expenses charged on consolidated fund. The salaries, allowances and pensions of the judges and the staff, as well as all administrative expense of the Supreme Court, are charged on the consolidated fund of India. Thus, they are non-votable by the Parliament, though they can be discussed by it. Fifth is conduct of judges cannot be discussed. The Constitution prohibits any discussion in Parliament or in a state legislature with respect to the conduct of the judges of the Supreme Court in the discharge of their duties, except when an impeachment motion is under consideration of the Parliament. 6 is ban on practice after retirement. The retired judges of the Supreme Court are prohibited from pleading or acting in any court or before any authority within the territory of India. This ensures that they do not favor anyone in the hope of future favor. Next, 7th is power to punish or its contempt. The Supreme Court can punish any person for its contempt. Thus, its actions and decisions cannot be criticized and opposed by anybody. This power is vested in the Supreme Court to maintain its authority, dignity, and honor. Next, 8th is freedom to appoint its staff. The CJI can appoint officers and servants of the Supreme Court without any interference from the executive. He can also prescribe their condition or service. 9th is its jurisdiction cannot be curtailed. The Parliament is not authorized to curtail the jurisdiction and powers of the Supreme Court. The Constitution has guaranteed to the Supreme Court jurisdiction of various kinds. However, the Parliament can extend the same. Last, 10th is separation from executive. The Constitution directs the state to take steps to separate the judiciary from the executive in the public services. This means that the executive authorities should not possess the judicial powers. Consequently, upon its implementation, the role of executive authorities in judicial administration came to an end. Next is jurisdiction and powers of the Supreme Court. The Constitution has conferred a very extensive jurisdiction and vast powers of the Supreme Court. It is not only a federal court like the American Supreme Court, but also a final court of appeal like the British House of Lords, the upper house of the British Parliament. It is also the final interpreter and guardian of the Constitution and guarantor of the fundamental rights of the citizens. Further, it has advisory and supervisory powers. Therefore, Aladi Krishnaswamy Iyer, a member of the drafting committee of the Constitution, rightly remarked the Supreme Court of India has more powers than any other Supreme Court in any part of the world. The jurisdiction and powers of the Supreme Court can be classified into the following. First is original jurisdiction. Second is writ jurisdiction, third is appellate jurisdiction, fourth is advisory jurisdiction, fifth is a court of record, sixth is power of judicial review, seventh is constitutional interpretation, and eighth is other powers. First is original jurisdiction. As a federal court, the Supreme Court decides the disputes between different units of the Indian Federation more elaborately and any dispute. A. Between the center and one or more states. B. Between the center and any state or states on one side and one or more other states on the other side. C. Between two or more states. In the above federal disputes, the Supreme Court has exclusive original jurisdiction. Exclusive means no other court can decide such disputes, and original means the power to hear such disputes in the first instance, not by way of appeal. With regard to the exclusive original jurisdiction of the Supreme Court, 2 points should be noted. One, the dispute must involve a question whether of law or fact on which the existence or extent of a legal right depends. Thus, the questions of political nature are excluded from it. To any suit brought before the Supreme Court by a private citizen against the center or a state cannot be entertained under this. Further, this jurisdiction of the Supreme Court does not extend to the following. A dispute arising out of any pre-constitution treaty agreement, convent engagement, synod, or other similar instrument. B. A dispute arising out of any treaty agreement, etc., which specifically provides that the said jurisdiction does not extend to such a dispute. C. Interstate water disputes. D. Matters refers to the Finance Commission. E. Adjustment of certain expenses and pensions between the center and the states. F. Ordinary dispute of commercial nature between the center and the state. G. Recovery of damages by the state against the center. In 1961, the first suit under the original jurisdiction of the Supreme Court was brought by West Bengal against the center. The state government challenged the constitutional validity of the Coal-Bearing Areas Acquisition and Development Act 1957 passed by the Parliament. However, the Supreme Court dismissed the suit by upholding the validity of the Act. Second is writ jurisdiction. The Constitution has constituted the Supreme Court as the guarantor and defender of the fundamental rights of the citizens. The Supreme Court is empowered to issue writ including habeas corpus, mandamus, prohibition, quo warranto, and certiorari for the enforcement of the fundamental rights of an aggrieved citizen. In this regard, the Supreme Court has original jurisdiction in the sense that an aggrieved citizen can directly go to the Supreme Court, not necessarily by way of appeal. However, the writ jurisdiction of the Supreme Court is not exclusive. The High Courts are also empowered to issue writs for the enforcement of the fundamental rights. It means when the fundamental rights of a citizens are violated, the aggrieved party has the option of moving either the High Court or the Supreme Court directly. Therefore, the original jurisdiction of the Supreme Court with regard to federal disputes is different from its original jurisdiction with regard to disputes relating to fundamental rights. In the first case, it is exclusive, and the second case, it is concurrent with the High Court's jurisdiction. Moreover, the parties involved in the first case are units of the Federation, center and states, while the dispute in the second case is between citizen and the government, central or state. There is also a difference between the writ jurisdiction of the Supreme Court and that of the High Court. The Supreme Court can issue writs only for the enforcement of the fundamental rights and not for other purposes. The High Court, on the other hand, can issue writs not only for the enforcement of the fundamental rights but also for other purposes. It means that the writ jurisdiction of the High Court is wider than that of the Supreme Court, but the Parliament can confer on the Supreme Court the power to issue writs for the other purposes also. Next, third is appellate jurisdiction. As mentioned earlier, the Supreme Court has not only succeeded the Federal Court of India but also replaced the British Privy Council as the highest court of appeal. The Supreme Court is primarily a court of appeal and hears appeals against the judgments of the lower courts. It enjoys a wide appellate jurisdiction which can be classified under four heads. A. Appeals in constitutional matters. B. Appeals in civil matters. C. Appeals in criminal matters. D. Appeals by special leave. First, A. Constitutional matters. In the constitutional cases, an appeal can be made to the Supreme Court against the judgment of a High Court if the High Court certifies that the case involves a substantial question of law that requires the interpretation of the Constitution. Based on the certificate, the party in the case can appeal to the Supreme Court on the ground that the question has been wrongly decided. B. Civil matters. In civil cases, an appeal lies to the Supreme Court from any judgment of a High Court if the High Court certifies first that the case involves a substantial question of law of general importance, and second, that the question needs to be decided by the Supreme Court. Originally, only those civil cases that involved a sum of rupees 20,000 could be appealed before the Supreme Court, but this monetary limit was removed by the 30th Constitutional Amendment Act of 1972. Next, C. Criminal matters. The Supreme Court hears appeals against the judgment in a criminal proceedings of a High Court if the High Court first has an on appeal reversed an order of acquittal of an accused person and sentenced him to death. Second, has taken before itself any case from any subordinate court and convicted the accused person and sentenced him to death, or third, certifies that the case is a fit one for appeal to the Supreme Court. In the first two cases, any appeal lies to the Supreme Court as a matter of right. In example, without any certificate of the High Court. But if the High Court has reversed the order of conviction and has ordered the acquittal of the accused, there is no right to appeal to the Supreme Court. In 1970, the Parliament had enlarged the criminal appellate jurisdiction of the Supreme Court. Accordingly, an appeal lies to the Supreme Court from the judgment of a High Court if the High Court first has on appeal reversed an order of acquittal of an accused person and sentenced him to imprisonment for life or for 10 years. Second, has taken before itself any case from any subordinate court and convicted the accused person and sentenced him to imprisonment for life or for 10 years. Further, the appellate jurisdiction of the Supreme Court extends to all civil and criminal cases in which the Federal Court of India had jurisdiction to hear appeals from the High Court but which are not covered under the civil and criminal appellate jurisdiction of the Supreme Court mentioned above. Next, D. Appeal by special leave. The Supreme Court is authorized to grant in the discretion special leave to appeal from any judgment in any matter passed by any court or tribunal in the country except military tribunal and court martial. This provision contains the four aspects as under. First, it is a discretionary power and hence cannot be claimed as a matter of right. Second, it can be granted in any judgment, whether final or interlocutory. Third, it may be related to any matter constitutional, civil, criminal, income tax, labor, revenue, advocates, etc. Fourth, it can be granted against any court of or tribunal and not necessarily against a high court, of course, except a military court. Thus, the scope of this provision is very wide and it vests the Supreme Court with a plenary jurisdiction to hear appeals on the exercise of this power. The Supreme Court itself held that being an exceptional and overriding power, it has to be exercised sparingly and with caution and only in special extraordinary situations. Beyond that, it is not possible to fetter the exercise of this power by any set formula or rule. Fourth is advisory jurisdiction. The Constitution under Article 143 authorizes the President to seek the opinion of the Supreme Court in the two categories of matters. A. On any question of law or fact of public importance which has arisen or which is likely to arise. On any dispute arising out of any pre-constitution, treaty, agreement, covenant, engagement, synod, or other similar instruments. In the first case, the Supreme Court may tender or may refuse to tender its opinion to the President, but in the second case, the Supreme Court must tender its opinion to the President. In both the cases, the opinion expressed by the Supreme Court is only advisory and not a judicial pronouncement. Hence, it is not binding on the President. He may follow or may not follow the opinion. However, it facilitates the government to have an authoritative legal opinion on a matter to be decided by it. So far, 2019, the President has made 15 references to the Supreme Court under its advisory jurisdiction, also known as consultative jurisdiction. This also mentioned below in chronological order. Remember, another name of advisory jurisdiction is consultative jurisdiction. So, first is Delhi Laws Act in 1951. Second is Kerala Education Bill in 1958. Third is Berubari Union in 1960. Fourth is Sea Customs Act in 1963. Fifth is Keshav Singh's case relating to the privileges of the legislature in 1964. Sixth is Presidential Election in 1974. Seventh is Special Courts Bill in 1978. Eighth is Jammu and Kashmir Resettlement Act in 1982. Ninth is Kaveri Water Disputes Tribunal in 1992. 10th is Ram Janmabhoomi case in 1993. 11th is consultation process be adopted by the Chief Justice of India in 1998. 12th is legislative competence of the center and states on the subject of natural gas and liquefied natural gas in 2001. 13th is the constitutional validity of the Election Commission's decision on deferring the Gujarat Assembly election in 2002. 14th is Punjab Termination of Agreements Act in 2004. 15 is 2G Spectrum case verdict and the mandatory auctioning of the natural resources across all sectors in 2012. Fifth is a court of record. As a court of record, the Supreme Court has two powers. A. The judgments, proceedings, and acts of the Supreme Court are recorded or perpetual memory and testimony. These records are admitted to be of evidentiary value and cannot be questioned when produced before any court. They are recognized as legal precedents and legal references. B. It has power to punish for contempt of court either with simple imprisonment for a term up to 6 months or with the fine up to 2000 or with both. In 1991, the Supreme Court has ruled that it has power to punish for contempt not only of itself but also of high courts, subordinate courts, and tribunals functioning in the entire country. Contempt of court may be civil or criminal. Civil contempt means willful disobedience to any judgment, order, writ, or other process of a court or willful breach of any undertaking given to a court. Criminal contempt means the publication of any matter or doing an act which first scandalizes or lowers the authority of a court, second prejudices or interferes with the due course of a judicial proceeding, or third interferes or obstructs the administration of justice in any other manner. However, innocent publication and distribution of some matter, fair and accurate report of judicial proceedings, fair and reasonable criticism of judicial acts, and comment on the administrative side of the judiciary do not amount to contempt of court. Next, sixth is power of judicial review. Judicial review is the power of the Supreme Court to examine the constitutionality of legislative enactments and executive orders of both the central and state governments. On examination, if they are found to be violative of the Constitution, ultra vires, they can be declared as illegal, unconstitutional, and invalid, null and void by the Supreme Court. Consequently, they cannot be enforced by the government. Seventh is constitutional interpretation. The Supreme Court is the ultimate interpreter of the Constitution. It can give final version to the spirit and content of the provisions of the Constitution and the verbiage used in the Constitution. While interpreting the Constitution, the Supreme Court is guided by a number of doctrines. In other words, the Supreme Court applies various doctrines in interpreting the Constitution. The important doctrines are mentioned below. You can see here are 13 doctrines. Okay. Next is other powers. Besides the above, Supreme Court has numerous other powers. A. It decides the disputes regarding the election of the president and the vice president. In this regard, it has the original, exclusive, and final authority. B. It inquires into the conduct and behavior of the chairman and members of the Union Public Service Commission on a reference made by the president. It is find them guilty of misbehavior. It can recommend to the president for their removal. The advice tendered by the Supreme Court in this regard is binding on the president. C. It has power to review its own judgment or order. Thus, it is not bound by its previous decision and can depart from it in the interest of justice or community welfare. In brief, the Supreme Court is a self-correcting agency. For example, in the Keswanand Bharti case 1973, the Supreme Court departed from its previous judgment in the Golaknath case 1967. Next D. It is authorized to withdraw the cases pending before the High Courts and dispose them by itself. It can also transfer a case or appeal pending before one High Court to another High Court. E. Its law is binding on all courts in India. Its decree or order is enforceable throughout the country. All authorities, civil and judicial, in the country should act in aid of the Supreme Court. Next F. It has power of judicial superintendence and control over all the courts and tribunals functioning in the entire territory of the country. The Supreme Court's jurisdiction and powers with respect to matters in the Union list can be enlarged by the Parliament. Further, its jurisdiction and powers with respect to other matters can be enlarged by a special agreement of the center and the states. Clear this one? Next is Supreme Court advocates. Three categories of advocates are entitled to practice law before the Supreme Court. They are: number 1, senior advocates; number 2 is advocates on record; and number 3 is other advocates. Next is comparison between Indian Supreme Court and American Supreme Court. Indian Supreme Court, its original jurisdiction is confined to federal cases, but in American Supreme Court, its original jurisdiction covers not only federal cases but also cases relating to naval forces, maritime activities, ambassadors, etc. Second, in Indian Supreme Court, its appellate jurisdiction covers constitutional, civil and criminal cases, but in American court, its appellate jurisdiction is confined to constitutional cases only. Third, in Indian, it has a very wide discretion to grant special leave to appeal in any matter against the judgment of any court or tribunal except military. But in American, it has no such plenary power. Fourth, in Indian, it has advisory jurisdiction, but in American, it has no advisory jurisdiction. Fifth, in Indian, it has scope of judicial review is limited, but in American, its scope of judicial review is very wide. Sixth, in Indian, it defends rights of the citizen according to the procedure established by law, but in American it defends rights of the citizen according to the due process of law. Seventh, in Indian, its jurisdiction and powers can be enlarged by Parliament, but in American its jurisdiction and powers are limited to that conferred by the Constitution. Eighth, in Indian, it has power of judicial superintendence and control over state high courts due to integrated judicial system, but in American Supreme Court, it has no such power due to double or separated judicial system. Next is articles related to Supreme Court at a glance. You have to remember this. Under Article 124, subject matter is establishment and constitution of Supreme Court. Under Article 124A, National Judicial Appointments Commission. Under Article 124B, functions of Commission. Under Article 124C, power of Parliament to make law. Under Article 125, salaries etc. of judges. Under Article 126, appointment of acting Chief Justice. Under Article 127, appointment of ad hoc judges. Under Article 128, attendance of retired judges at sitting of the Supreme Court. Under Article 129, Supreme Court to be a court of record. Under Article 130, seat of Supreme Court, that is where? In Delhi. Under Article 131, original jurisdiction of the Supreme Court. Next, under Article 131A, exclusive jurisdiction of the Supreme Court in regard to questions as to constitutional validity of central laws, that is repealed. Under Article 132, appellate jurisdiction of Supreme Court in appeals from High Courts in certain cases. Under Article 133, appellate jurisdiction of Supreme Court in appeals from High Court in regard to civil matters. Next, under Article 134, appellate jurisdiction of Supreme Court in regard to criminal matters. Under Article 134A, certificate for appeal to the Supreme Court. Next is under Article 135, jurisdiction and powers of the Federal Court under existing law to be exercisable by the Supreme Court. Under Article 136, special leave to appeal by the Supreme Court. Under Article 137, review of judgments or orders by the Supreme Court. Next, under Article 138, enlargement of the jurisdiction of the Supreme Court. Under Article 139, conferment on the Supreme Court of powers to issue certain writs. Okay, that we already discussed. Next is under Article 139A, transfer of certain cases. Next, under Article 140, ancillary power of Supreme Court. Next, under Article 141, law declared by Supreme Court to be binding on all courts. Next is under Article 142. Under Article 142, enforcement of decrees and orders of Supreme Court and orders as to discovery, etc. Next, under Article 143, power of President to consult Supreme Court. Next, under Article 144, civil and judicial authorities to act in aid of the Supreme Court. Next is under Article 144A, special provisions as to disposal of questions relating to constitutional validity of laws, that is also repealed. Next, under Article 145, rules of court, etc. Next, under Article 146, officers and servants and the expenses of the Supreme Court. Next, under Article 147, interpretation. Next is, these are the notes and some references. First is, before 1950, the British Privy Council had the jurisdiction to hear appeals from India. Second, in a pre-presidential reference 1998, the President sought the Supreme Court's opinion under Article 143 on certain doubts over the consultation process to be adopted by the CJI as stipulated in the 1993 case. To a Supreme Court advocates on Record Association and another versus Union of India 2015. Third is A.N. Rai was fourth in seniority. The three superseded judges was J.M. Selat, K.S. Hegde and A.N. Grover. All the three judges resigned from the Supreme Court. They were superseded due to their judgment in Keswanand Bharti case 1973, which was not favorable to the government. Next, fourth is he was H.R. Khanna and two resigned. His dissenting judgment upholding the right to life even during emergency in the ADM Jabalpur versus Shivkant Shukla case 1976 was not appreciated by the government. Next, fifth is an impeachment motion for the removal of a judge does not lapse on the dissolution of the Lok Sabha. Next, sixth, in 1950, their salaries were fixed at 5,000 per month and 4,000 per month respectively. In 1986, their salaries were raised to 10,000 per month and 9,000 per month respectively. In 1998, their salaries were raised to 33,000 per month and 30,000 per month respectively. In 2009, their salaries were raised to rupees 1 lakh per month and 90,000 per month respectively. 7. The Criminal Procedure Code 1973 has affected the separation of judiciary from executive under Article 50, the DPSP. Act is pre-constitution means that which have been entered into or executed before the commencement of the constitution and which continues to be operation after such commencement. Ninth is, this means that the inter-government agreements, in example, the agreements between states or between center and states, can exclude the original jurisdiction of the Supreme Court in so far as the dispute arising out of them are concerned. Next, 10th is the Interstate Water Dispute Act of 1956 has excluded the original jurisdiction of the Supreme Court in disputes between states with respect to the use, distribution or control of the water of interstate river or river valley. Next and last, 11th, these include treaties, covenants, etc. between the central government and the formerly princely states during 1947 to 1950. Now I am going to discuss some important questions. I think these questions may ask in your exam. So, the aspirants preparing for UPSC, CAPF, PCS, SSC, CDS, Afcat, Ctet and other competitive exam, this set includes difficult and simple questions. We hope that the quiz will be helpful in your success. So first question is, from which source India got concept of single order of court? So option A is Government of India Act 1935, option B Government of India Act 1919, option C is Pitt's India Act 1773, option D none of the following. So right answer we already discussed that. Option A is the right answer, Government of India Act. Next question number second, which of the following statement is not true about India's Supreme Court? Option A, Article 124 to 147 and Part 5 of the Indian Constitution informs about composition and powers of the Supreme Court. Option B, the Supreme Court was inaugurated on January 28, 1950. This is also true. Option C, at present there are 35 judges in the Supreme Court. This is not correct. Okay, this is not true. So right answer is option C. At present how many judges? 34 including CJI or excluding CJI. At present there are 33 judges in the Supreme Court since 2019. Okay. Next question number 3 is, which qualification is wrong for being a judge in the Supreme Court? A, it is a compulsory to be a citizen of India. Option B, he should be respected jurist in the eyes of Parliament. Option C, must be a judge in the High Court for at least 5 years. Option D, he should be a lawyer in the High Court for at least 10 years. So right answer is B, he should be a respected jurist in the eyes of Parliament. Okay, in the eyes of President instead of this, he should be respected jurist. Next is question number 4. Which statement regarding the tenure of judges of Supreme Court is not correct? Option A, judge of the Supreme Court can remain in office till the age of 65 years. Option B, judge of the Supreme Court gives his resignation letter to the Chief Justice. Okay, this, I think this one is your answer. Option C is on the recommendation of Parliament, he can be removed by the President. Next, option D is Supreme Court judge can be removed only in the condition of misconduct. So which is not correct related to Supreme Court? Option B, a judge of the Supreme Court gives his resignation letter to the President, not CJI. Okay. Next is question number 5. Who can remove the judge of the Supreme Court? Option A, Chief Justice of the Supreme Court. Option B, only President. Option C, only Parliament. Option D, both Parliament and President. Yes, both Parliament and President. Right answer is D. And explanation you can see here. Next is, what is the current salary of Chief Justice of the Supreme Court? Option A, 1 lakh rupees. Option B, 2.80 lakh rupees. Option C, 90,000 rupees. Option D, 2.25 lakh rupees. So right answer is 2.80 lakh rupees. Option B is a right. From the year 2018, the CJI of the Supreme Court gets salary of rupees 2.80 lakh per month. Okay. Next is question number 7. The President can declare a judge an executive Chief Justice of the Supreme Court of India when the post of Chief Justice is vacant. Option B, Chief Justice is temporarily absent. Option C, Chief Justice is unable to discharge his obligations. So right answer is all of the above. Next, question number 8. Who among the following has the right to establish the bench of the Supreme Court elsewhere in the country? Option A, the Chief Justice of the Supreme Court. Yes, he can. But next option is the President of India. Option C is the Parliament. Option D is, yes, right here, the CJI has the right to allow to establish bench of the Supreme Court elsewhere in the country with prior approval of the President. Okay, so right answer is D. Next, question number 9. Which of the following articles talks about the establishment of the Supreme Court? Option A, Article 176. Option B, Article 153. Option C, Article 124. Option D, Article 324. So right answer is under Article 124. Option C is a right answer. Next and last, question number 10. Which of the following is not matched correctly? Option A, Article 145, salary of judges. Option B, Article 143, power of President to consult with Supreme Court. Option C, Article 141, orders of Supreme Court is applicable to all courts of India. Next, option D, Article 139, powers of Supreme Court to issue writ petition. So option A is not matched correctly. Under Article 145 is related to rules of Supreme Court, not the salary of judges. Salary of judges comes under Article 125. So thank you students. Over for the day. Hope you like this video. और हमारा एक चैनल है यूट्यूब पे भी, वो सब्सक्राइब कर सकते हैं आपको यदि अच्छा लगे. और हमारा एक ऐप है प्ले स्टोर पे उड़ान एकेडमी के नाम से. वहाँ पे आपको हिंदी मीडियम और इंग्लिश मीडियम दोनों ही जो मीडियम से स्टूडेंट्स बिलोंग करते हैं उनके लिए बेनिफिशियल है. वहाँ पे हिंदी में भी स्टडी मटेरियल है, इंग्लिश में भी है. वो आप फ्रीली वहाँ से आप ले सकते हो, फ्री स्टडी मटेरियल. इसके अलावा हम डिस्काउंटेड टेस्ट सीरीज़ भी वहाँ पे प्रोवाइड कर रहे हैं. यू विल गेट डिस्काउंट अप टू 99%. ओके, सो डाउनलोड कीजिए उसको ज़्यादा से ज़्यादा. एंड over for the day. Thank you so much.